and constitutional criminal procedure. I'm here today to talk about the case of Trump versus Vance, which was issued by the Supreme Court yesterday. Just first, the background of the case. Cyrus Vance is the Manhattan DA, and he subpoenaed business records of Donald Trump related to some unspecified criminal investigation. That is, the subject matter is not clear. The best guess is that the case Vance is developing has to do with the payment to Stormy Daniels for her silence because Trump was named as a participant, individual number one, in the indictment of, Michael Cohen. The subpoena went to Mazars USA, which is Trump's accounting firm. And then Trump sued in the U.S. District Court for an injunction against the subpoena directed to DA Vance. The court decided 7-2 that the president did not have the ability to stop the subpoena at this time on two grounds. One is that he had claimed that he was absolutely immune from the subpoena. And the court actually rejected that proposition unanimously, and we'll talk about that. The other holding of the court is that Trump had argued that the DA had to meet a heightened standard before he could go forward with the subpoena. And that's the 7-2 vote. That's the justices, other than Thomas and Alito, who said that there is not a reason to impose a higher standard. So the case was remanded for further proceedings. I'll only talk about the Roberts and Alito opinions. The Roberts opinion begins by stating a broad principle that every person has a duty to provide evidence, facts in their possession when a court asks for it. As Justice Robert puts it, the public has a right to every man's evidence. It's impossible to overstate the significance and the power of that principle, that the state has a right to every person's evidence. If that weren't true, then courts, and not only courts, but legislatures who issue subpoenas, administrative bodies who issue subpoenas, would not be able to get the information they need to function. Without that, it's very hard to see how you maintain a rule of law society at all if you cripple our legal institutions to that extent. So that's why I say it's almost impossible to overstate the importance of this principle. So that principle is, to put it in a little bit of perspective, that principle is subject to a very few strictly drawn exceptions, the principal one being the privilege against self-incrimination. And that's almost it.
Dear?
Sorry, Professor Weisberg, could you mute?
I'm trying to get audio.
Yeah, I just need you to mute. Thank you.
Mm-hmm.
He has to unmute. You're dropping the line.
Sorry, do you have me now? Okay. So you're able to hear me. I'm sorry. There is, as I was saying, the only exception, or one of the few exceptions to the duty to provide evidence, is that of the self-incrimination clause. Now, there's nothing that Trump raised that even approaches that. So you can see what a heavy burden he was taking on by attacking this subpoena. Just as a side point, this principle, as I say, is powerful, but it's also quite old. Justice Roberts, in his opinion, dates it to 1742, and that's actually not correct. The principles first expressed in what's called the Countess of Shrewsbury's case in 1612, so he's off by about 130 years. The Countess of Shrewsbury case, 1612, was actually cited and quoted by the Supreme Court itself in a 1919 case. So in the United States, it's recognized that this principle goes back 400 years and more, first in the English colonies in America and then in the United States. So Roberts's opinion is really clear. Not only that there is no absolute immunity, but also that the state DAs don't have to meet a special heightened standard. So aside from the broad principle that I've been talking about, the main argument that Roberts makes is that there are many other more specific grounds on which Trump can oppose this subpoena that fall well short of absolute immunity or even some sort of heightened standard of proof, but that are so numerous that the president will be adequately protected. So those principles include, or those grounds include, an argument that the subpoena has been issued in bad faith, with malice for purposes of harassment, based on prosecutorial misconduct, irrelevance, overbreadth, burdensomeness, claims that the subpoena is intended to influence or retaliate for a president's decision or act, specific showing that the subpoena impedes or conflicts with the president's normal duties. And the thing to notice about that is that that is a virtual, that's a virtual roadmap for the Trump's attorneys to use to further delay and obstruct this proceeding. The important thing, though, is to see that every one of those grounds is available to anyone who is subject to a subpoena. So again, Trump is just put on the same level as everyone else who receives a subpoena, which is really quite significant. Another practical effect of the case that people hope to see was that Trump might be politically damaged. Not to say that that was DA Vance's goal, but that's certainly something that people who really are oppose Trump on many grounds would like to have seen. That's just not going to happen. First of all, for the reason that I just said, the case is going back to the lower courts, and that's where Trump would raise, if he can, any of these other grounds on which to oppose the subpoena. And then we're back in the same cycle of litigation that we're just finishing up now. There's another reason why the public isn't going to see the information that would be, if ever, turned over by Mazars to DA Vance. Even when the DA gets the business records, they'll be used only in front of the grand jury. Now, grand jury proceedings are secret. And this is something that is taken very, very seriously by the courts and the prosecutors running the grand jury. It is drilled into the heads of the individuals serving on the grand jury that these are secret proceedings and that they will be in violation of the law if they were to disclose any information that they hear as grand jurors. And as a result, grand jurors very seldom reveal anything that's gone before the grand jury. If there is an attorney who were involved in the grand jury proceedings and who turned over or leaked any information that had been before the grand jury, that attorney certainly would be disbarred. So the secrecy of grand jury proceedings is very powerfully enforced and very rarely breached. So the public is unlikely to see or receive from a leak from the grand jury itself any of this information. Even if well, even if there's a prosecution, if there's not a prosecution, everything will just be sealed and filed away. If there's a prosecution, even then, what is happening with the grand jury in relation to that prosecution is the grand jury is functioning in an investigative capacity here. So think of them like the police or the FBI. They're collecting a lot of information. But when that case goes into prosecution mode, so to speak, charges are filed, an indictment is issued. Then in preparation for the trial, the lawyers for the government are going to winnow out that evidence. They're only going to bring the evidence that they need to prove their case. They're only allowed to bring the evidence that they need to prove their case. And so even if this information is turned over to the grand jury, it's not going to come out until literally years later, if and when there's a trial. And even then, all of that subject to the rules of evidence, including, of course, relevance to the particular charges. So this is not as big a loss for Donald Trump as it might seem. He can still delay this, and even in the normal processes, this is something that is not going to get before the public very soon or ever. Now, I want to go back to the absolute immunity point because it's particularly important. As I said, the court held unanimously that Donald Trump does not have absolute immunity from this subpoena. The idea that the president wouldn't have any duty to respond to this subpoena is really a breathtakingly bold claim. But the thing you might not be aware of is that this is part of an agenda that is being pursued by a significantly large faction of very conservative lawyers. They're pursuing what's called the unitary executive theory of government. And this has been pursued at least since the Reagan administration. The unitary executive theory, frankly, is absolute lunacy. Here's the argument that they make, and see if this comports with your understanding of American and constitutional history. The argument is that in the Declaration of Independence and in the Revolutionary War, the United States took its sovereignty from King George. Then when the Constitution was written, the unitary executive theory has it, every aspect of that sovereignty was assigned to the several branches. Some of it went to the courts, some of it went to Congress. The unitary executive theory is that everything else, literally the sovereignty that was held by King George and all his powers, that landed with the president. Now, this, as I say, makes absolutely no sense. Article 1 creates Congress. Article 2 creates the executive. That's significant. It's just logical. Congress passes the law, and the function of the president, the executive, is to execute the laws passed by Congress. That's his job. And the Congress, of course, has the power of the purse to prevent the president from going too far in whatever way he might try to do to aggrandize his own power or to pursue anything that Congress has not authorized. They've got the power of the purse. More generally, historically, at the time of the founding, there was an absolute dread of the executive. Any sort of executive was seen to be as something that was too close to a king for comfort. So, for example, the first Pennsylvania Constitution did not have an executive at all. It had courts and it had a legislature with no executive. Now, that didn't work, but that's an indication of the dread with which the founding generation viewed the executive. So the unitary executive theory is just not viable, but you see it in this case. You see that unitary executive theory being pursued in this claim of absolute immunity from the subpoena. This is also visible in Justice Alito's dissent. His opinion turns on an extensive account of the responsibilities of the president, And the claim that to allow this subpoena would just undermine the presidency completely. But Alito doesn't talk about the subpoena. Alito's argument is that a prosecution of the president would undermine the presidency. So it's an extraordinarily broad argument, and it's an easy one for the majority to knock down. As Roberts' opinion explains, there is ample opportunity to prevent any harm or interference with the presidency farther down the line on specific grounds of opposing the subpoena. Just because the president's records are requested by the grand jury, that in no way implies that he will ever be a defendant in a criminal prosecution. And so the parade of horrors, and it's actually pretty convincing, that would result from a president being prosecuted and possibly convicted of a crime, that all may be true, as Alito says. The thing is, it's completely irrelevant. But you have to notice also that Alito must have known that. For some reason, he has this impulse to defend the presidency on the broadest grounds. That's the unitary executive principle or theory at work. The other thing that tells you that is that Justice Alito starts his description of the powers of the presidency with the commander-in-chief clause and with the proposition that the president is in charge of foreign policy. The unitary executive advocates always start there because that is where indeed the president's powers are at their zenith. But to start there to emphasize those two powers of the presidency really distorts the structure of the presidency completely. But again, the point is that Alito, in not only in supporting and being willing to grant this claim of absolute immunity, that's part of a bigger picture of some absolute power in the president under this theory of, as I say, a substantial number of conservative jurists and scholars. Okay, so there's a second defect in Alito's opinion that, in my view, every member of the court really suffers from. All of these opinions suffer from. And that is that they really don't pay attention to the fact that the Constitution reserves powers to the state. And one of the principal ones that's reserved is the police power, the power to enforce criminal law. As you know, 99%, maybe 95% of criminal prosecutions in the United States are brought by the states, not by the United States. So the police power of the states is quite significant. So here's what I think they miss. Alito says that the state DA has to make a heightened showing of direct relevance to a specific prosecution in order to subpoena the president. And one argument he makes is that the state governments have no power to intervene in and in any way obstruct the functions of the departments of the United States. And of course, that's in the Supremacy Clause, and it's also in the case of McCulloch versus Maryland. There, Maryland tried to tax the Bank of the United States. The court said they couldn't do that. That would be the states interfering with United States government functions. Roberts meets this argument by making the same argument he makes throughout, which is that any serious interference with the president is going to come up way down the road. And there's also, as a separate matter, a separate doctrine, if a state officer actually does directly impede federal law, they can be ordered to conform to federal law just like anyone else. But what Roberts doesn't say, maybe doesn't see, is that all of that's irrelevant. We don't have a case here of the state governments interfering with federal government operations. What we've got here, at least equally, and to my mind, even more importantly, we've got the federal government interfering with state functions. It's completely the reverse. Remember, Trump went to US District Court to have this subpoena quashed. And the idea is that the district court is going to step into a state criminal prosecution. Now, that violates the state's powers. And the court has recognized this bar against the federal court stepping into state court proceedings in a case called Younger versus Harris, which both the Second Circuit and the Supreme Court said don't apply here. But that case wasn't based on any claim under the police power. That claim was based just on general equity and federalism grounds. So there's an important issue here that I think that everyone missed. Frankly, I don't know if it was raised by an amicus brief, but I'm afraid it might not have been. So finally, just the last point is the central issue in this case, as I've said, is this principle that the government has the power to subpoena anyone and get any information they've had. That's established in the United States in the United States versus Burr prosecution case dated 1807. Now, it's true that that case states the general principle. It's true that it applies it to a case involving the president. And so it's important, it's central to the court's rationale. But if you read the opinion, I think it's kind of odd. Justice Roberts starts the explanation, the analysis of United States versus Burr with the sentence, in the summer of 1807, all eyes were on Richmond, Virginia. So he's writing like a detailed historical account, and he does. He goes into far more detail than is necessary to decide this case, talking about what Aaron Burr did after he murdered Alexander Hamilton. He absconded from New Jersey, first of all, to avoid a murder prosecution. But then he went out west and organized a scheme to set up a territory under his control, apparently in Mexico. Part of that scheme was to draw the United States into a war with Spain. So an absolutely crazy set of events. Take a look at the way Roberts describes it, though. To me, it sounds like he's setting up a sequel to Hamilton, because Burr is every bit as interesting as Hamilton. So that's Trump versus Vance. I hope you enjoy reading it as much as I did, and I hope this is helpful. Thanks. So I guess we can take any questions you might have. You could raise your hand in the participants pane, or just write something in chat if you'd like to, and I'll try to answer a few of those questions. Edward. Hi, Eddie, you're still muted.
Go ahead.
Eddie, you're still muted. Oh, Yamadalis? I guess Eddie dropped off.
Yeah, hi, can you hear me?
Yes, I can.
Yes, hi. I was wondering if you could go over the alleged horribles from having the president be amenable to criminal prosecution.
Oh, it's a very long list. I'm tempted to pull out the Alito opinion, but it's pretty much what you would expect. Things such as if the president has to appear for a criminal trial where he's the defendant, unless we're going to try him in absentia, he's going to be in attendance at the trial. Any trial is, which is important enough to bring against the president, is going to take a while. So what are we going to do? We're going to have the president sitting there week after week with his advisors coming in and out, where he's giving orders on emergent situations in small recesses day after day after day, which then would lengthen it out. Goes from that to what if the president were to be convicted and then imprisoned or even held in custody custody during the trial. What are we going to have? His advisors in an adjacent cell where they can stay in touch with him and stay in touch with what is going on outside. And then Alito casts the motives of DA Vance in the worst possible light, recounting the fact that Thomas Dewey, who was a presidential candidate against President Truman, and prior to that, the governor of New York, Dewey had started his career as a DA in New York, and had used that to aggrandize himself. And so for some reason, Alito inserts that little bit of history into his opinion in the Vance case. So there's a strong indication, or allegation really, that due to the grandstanding of the DA, that the president might be damaged in this way. And of course, we can't have that. The other interesting thing that Alito says is that sorry, I just lost my train of thought. Oh, the other thing that he says is something that you have probably saw in the journalistic coverage of this, which is that they were pointing out that there are 2,300 or more local district attorney offices in the United States. And they're saying, well, what if, thousands of DA offices issued thousands of subpoenas against the president? That would grind, the West Wing to a halt. Well, if you put that in context, the court held in Jones versus Clinton that Bill Clinton had to respond to a subpoena. He sat for a deposition, and that was in a case brought by an individual. Now, if you think about it, how many individuals are there in the United States, right? Hundreds of millions. And so that parade of horribles hasn't come about. We haven't had, millions of cases brought by millions of individuals against the president as a way to obstruct him. So why worry about the 2,300 DAs? They can behave at least as responsibly as other American citizens and not bring harassing lawsuits and subpoenas. That's about what he says and more.
I guess what I have more of a hard time wrapping my head around is, how is the president being busy worse than allowing him to do whatever he wants?
Well, we haven't had a president who feels that he can do whatever he wants. And there are other constraints. I mean, even though this one pretty clearly doesn't understand what the presidency is and does want to do whatever serves his ego at that particular minute. Even then, he's been constrained by, some other limits on, by the real limits on presidential power, which he unfortunately fortunately hasn't been able just to wish away. So in the context of things, I think that a subpoena was really one of the most minor things that might interfere with the presidency. And so, it's not going to be a check on him anyway, if that answers your question.
Yeah, it does. I mean, I disagree, but
well, I'm doing the best I can.
No, it's not you. No, obviously I don't agree that, particularly like with Trump, the checks that we usually have are particularly working, but you did answer my question about as far as what the argument is, even if I don't agree with what the argument is.
Okay,
good. Thank you.
Yes, sure. Any other questions? Hi, Eddie.
Hi, okay, I guess I'm here now. So are there precedents for considering the president's more kind of president-specific or executive-specific points of opposition to the subpoena? Like the idea that it would impede, or like when it goes back down, like that it will impede or conflict with his duties, or that, this could be a retaliation for official acts which are within his discretion. Is there kind of precedent to weigh those more president-specific points of opposition to the subpoena.
Yeah, I mean, as far as being president specific, this claim of absolute immunity is clearly president specific. The court is sending it back down. And really the second most important line of thought in Roberts's opinion is that he can, when it goes back down, he can claim that this, another subpoena is issued, that the subpoena is harassing, that the subpoena will actually interfere with the execution of his powers, and on and on and on. There's a list of about a dozen things that both Roberts and Kavanaugh in his concurrence, about a dozen things that they mention that are more specific claims of the kind that Trump was making in very general terms. And the gist of it is, well, all of that stuff is down the road. We don't know if it's ever going to happen, so we don't need to worry about that now. And he has the ability, and again, if he's trying to protect the presidency, then he protects the presidency in that way.
Well, how will the courts below decide if it really is retaliation or harassing? What
Well,
will
that's
to decide that?
Yeah, I mean, they're going to have to decide that based on the arguments of the parties and the state of affairs at the time.
Okay.
If what you're asking is, by what standards or under what rules they would make those decisions, they probably would have, in whatever jurisdiction it arises in, they probably have some cases about what constitutes harassment. And they're not going to have any cases probably about what impedes the duties of the president. But they'll have some on harassment, some on bad faith, most likely.
Yeah. Okay. Thank you.
Okay. Yeah. Let's see. Anyone else? All right. I think we're over time anyway. So I will call a halt now. I appreciate your stopping by. I hope this was helpful. And I hope to see you all in person as soon as possible. But in the meantime, take care and be well. Okay?